At this time, I wanted to ask you all to silence your cell phones, turn them to vibrate. I know that this is a working day for all of you, so if you needed to step out to take a phone call, go ahead and do that. Just go out the back door. You can watch through the TVs outside, so you won't miss anything. We understand. Also, any other electronic devices, go ahead and silence those at this time. I wanted to introduce Second Ward Councilman, Councilman Mike Trapp, who will present the mayor's proclamation. Mr. Trapp.
All right, Second Ward represent. Nobody has called us apathetic in many, many years in the Second Ward. Yeah, so it is my great duty to welcome you to this great event. It just keeps getting bigger and bigger, and it covers a really important topic. I'm not going to delve into that except to say that city government has been active on issues about affordable housing and about fair housing, and there is a lot of overlap between those two topics. There's a lot of economic, structural issues that determine where people live. Right now, we're concluding the work of a fair housing task force. Betsy Peters and myself have chaired a group of citizen volunteers, and with our able staff have dug deeply into housing patterns and data, and we've looked at a lot of maps, and we've brought in a lot of experts, and we have had robust discussions, and we're developing a housing policy statement that's going to come back to City Council to provide some kind of intellectual capital towards pointing us towards the North Star of where everyone has access to decent and affordable housing, and that we can look at disrupting our segregated living patterns. The big thing that's leapt out to me over the work of this task force is we have a lot of segregation in Columbia, but we don't have African American neighborhoods. We have integrated neighborhoods that seem very healthy as far as the racial and economic balance, and then we have a number of these 99% and higher white neighborhoods. And that's really what we need to look to address, is what can we do to change those housing patterns? And if there was an easy solution, I think we would do it. I think so. I can tell you that it's not going to be easy, but the reward will be great. If we can have more families with diverse backgrounds and low to moderate incomes that are living in neighborhoods with high opportunity, we're going to have different results. Right now, our poverty in Boone County is what we call sticky, which means if you're born poor in Boone County, far more than most other counties in the United States, you're likely to die poor. And so if we're going to want to reduce the long-term stickiness of our poverty, we're going to have to do something about reserving the highest opportunity neighborhoods for a very exclusive population that may not fit all of us. And so that is the issue of our generation. Now I'll look at my remarks. I'm told that I said, all right, well, I prepared some talking points for you just in case you don't want to talk extemporaneously, and as you have every single year that you've ever done this. So on behalf of Mayor Treese, I'll tell you, doing a early April event every 3 years, you never know who the mayor's going to be, and so they're never asked to deliver their own proclamation because there's no assurance that the one who said, yeah, I'll sign a proclamation, is going to be around to read it. So and they're often, So for that reason, amongst many others, I'm always proud to read the proclamation. So. This is what we're proclaiming. Whereas, on April 11th, 1968, the Fair Housing Act was signed into law by President Lyndon Baines Johnson. And whereas a strong community requires quality education, good jobs, and a sound financial base, which all starts with access to decent, affordable housing for all citizens. And whereas discrimination in housing or lending and homelessness negatively impact the overall well-being of the community. And whereas Chapter 12 of the City of Columbia Code of Ordinances makes it unlawful for any person to discriminate in housing or lending against an individual because of that individual's familial status, race, color, religion, sex, national origin, ancestry, marital status, disability, sexual orientation, or gender identity. And whereas the City of Columbia's 2016 to 2019 strategic plan priorities include social equity to strengthen the community so all individuals thrive by supporting neighborhoods, increasing home ownership, and increasing the stock of affordable, energy efficient, and universal design homes. And whereas the City of Columbia, Missouri is committed to the issue of fair housing for all these reasons, today has been Fair Housing and Lending Month in the City of Columbia. Can we a round of applause? And I will present this. And I'm going to go on to my script. So we are blessed in Columbia to have some real experts in the field, and you have going to see many of them today, and I've gotten to work closely with some, and some I don't know, but I want to recognize Rigel Oliveri, Randall Cole, and Krekel for volunteering their time to share their knowledge and expertise here today. I want to thank the Columbia Board of Realtors and Speaker Nate Johnson for providing the afternoon fair housing program for the realtors this afternoon, and the city's Building Inclusive Communities team for providing the afternoon workshop. We also want to thank our sponsors of the event. We couldn't do it on our own. This is a great community collaboration. The Missouri Commission on Human Rights, Columbia Housing Authority, the Columbia Apartment Association, Central Bank of Boone County, and the City of Columbia Human Rights Commission and Disabilities Commission, the city staff and their departments for their contributions to today's program. Most importantly, I would like to thank you for attending this program and showing your commitment to fair housing and lending and to building a better community in Columbia. I hope you enjoy the program. Thank you and good morning.
Thank you, Councilman Trapp. How exciting. Love anything with a gold seal on it. It's like a gold star. Before we start with our presentation, I just have a few housekeeping matters to run over. I wanted to thank Central Bank of Boone County for sponsoring our breakfast. So if you guys got to enjoy some bacon, which Bill Canton was very excited about, thank you for that, Central Bank. We have a microphone set up for questions, so please speak into the microphone with your questions so that everyone can hear you. Instead of shouting them out, we want to acknowledge the fact that people may have different hearing abilities, so please use that microphone. Bathrooms are located in the lobby just past the information desk and the robot in the lobby. Refreshments and snacks are located in rooms 1A and 1B, which is out here on the left-hand side where the breakfast was. There will be breaks throughout the day. This program has been improved as an inclusive excellence event. You can get your passport stamped at the registration table when you checked in. Your materials include a survey. Please complete that survey and return it to the registration table or at the back of the room as you leave. Your feedback is appreciated, and your input is used to plan the future sessions. We hope to continue this each year, so please take the time to fill out those evaluations. And today's event has been approved by the Missouri Bar for 6.3 MCLE credit hours. For licensed real estate professionals, you can earn 3 core credits for attending the Focus on Fair Housing session this afternoon. Please be sure you have signed in so that you can get your credits. The Board of Realtors will be submitting the final attendance list to the MREC. So if you're a licensed real estate professional and want those core credits, you must be physically present in the classroom 100% of the time during that presentation. Certificates will be available at the end of that session today. So be sure to pick up your own certificate and check your certificate for accuracy. It's your responsibility to keep that certificate in a safe place until your license is renewed, as you may be asked to send in copies of your CE certificates with a renewal notice. And if you haven't signed in, please do so before you leave today. And again, that registration table is straight through the doors and on the right-hand side. Our first speaker today is the fabulous Randall Cole. Randy oversees the city's affordable housing efforts as well as other community and economic development efforts funded by the Community Development Block Grants, so CDBG. So if you hear him say that, that's what CDBG means. Home program and local funding. He has overseen expanded efforts in improving energy efficiency, universal design, and HUD-funded projects and implementing the development of Columbia's first affordable net zero energy use home. Randy holds a master's in public administration from the Truman School of Public Affairs. Hey, me too. Good job. Where he was inducted into the Rollins Society for his volunteer and public service involvement during graduate school. Prior to working for the city, Randy worked for Central Missouri Community Action as the Energy Conservation Coordinator, where he oversaw the Department of Energy's low-income weatherization program, serving 8 counties in mid-Missouri. Randy was responsible for CMCA's award of the Sustainable Energy Resources for Consumer grant through the Department of Energy, resulting in the installation of 15 geothermal systems and 27 solar water heaters in Columbia's low-income neighborhoods. Welcome, Randy.
All right, thank you, Andrea. And good morning. I'm Randy Cole, the Housing Programs Manager. Really happy to be here this morning. So I'm going to talk a little bit about what we do as the Housing Programs Division. A lot of folks don't know everything we do, so I thought I'd cover that this morning. But then also take a little bit deeper dive into what we're doing with our Fair Housing Task Force. We'll cover a lot of ground, but hopefully I can get through it to where we've got enough time for questions. I got about 30 minutes, so we'll just dive on in. So I wanted to start out with why our work is important. So this is over on Lynn Street back in August of 2014. So some folks may have heard of our work with the Community Land Trust over on Lynn Street. You can see we have a couple of homes there that were vacant and dilapidated. The first time I interacted with this neighborhood was a complaint about both of these homes having siding coming off, blowing out into the yard and then into the neighbor's yard. So that was kind of our first interaction. You can see a couple years later, that's what that side of the street looks like. All the utilities are undergrounded. We have new affordable homes there where we have homeowners living there, and it's stabilizing the neighborhood. And we utilize a lot of neighborhood input to get to that point. So that's a big picture of why our work is important. This is across the street. The following, I think 2 years later, over at the Lynn Street Cottages, doing our ribbon cutting with a lot of people in the neighborhood and in the community and the business community that were all a part of that planning effort. So that's really kind of why we do the work. That's why our work's exciting, because we're changing neighborhoods, we're getting people involved, and we're keeping people involved as we plan for more work. Kind of another project I'll highlight is our 3rd and Forest alleyway. We're going to be redoing an alleyway over on between 3rd and Forest, and then also improving some affordable housing on 3 different properties there with the Community Land Trust. And really, that's come about through all the efforts of the Ridgeway Neighborhood Association being involved, kind of helping us figure out what to do there. So really, why our work is important is because we connect with the neighborhoods and help make our neighborhoods better. So a little more into detail who we are and what we do. So we're a grant administration office. So we administer grants, grant funds out to local organizations to do different affordable housing and community development work. We help people with renovating their nonprofit facilities, doing job training with JobPoint, other folks. But we do all of our federal reporting, and we steward resources. So a lot of resources flow through our office, so we make sure we're complying with all the federal laws and regulations and things like that. But we also do program delivery, so we acquire and demolish vacant and dilapidated homes. We operate a rehab program. We have a down payment assistance program that's had a lot of success recently. One of our persons that works in the office, Gary Anspaugh, is about to have his 1,000th down payment assistance education attendee through classes in his 100th class. That's kind of an exciting point. It should hit in July, I think. But yeah, it's a great program that has a lot of impact. We do homebuyer education, credit counseling, and then we also have the Columbia Community Land Trust, which is the entity that stewards all of our investments in affordable owner-occupied housing. So kind of got a lot there. But that picture is from City Hall's selfie day, so that's why it's a little goofy. But that's our team of 4 people, and we handle a lot of work. So this is just what one of our homebuyer education classes over the last 5 years. We've educated about 613 folks, done about 142 direct assistance of $7,500 to first-time homebuyers. The average first mortgage of those home buyers is around $115,000, so that's a really big economic impact if you think about those numbers. This is something new that we've started with Veterans United Lighthouse program. We're doing a credit education and one-on-one consultation program that we're doing about twice a year, where folks can bring in their credit report, work with a one-on-one counselor to figure out what's the next step, how do I lean into my credit issues, and get that cleaned up and get on a path to good credit and potential home ownership. These are some of the homes at Lynn Street Cottages. Again, we took a lot of partners to make that happen, from both the nonprofit, private sector, other folks in the community. I'd encourage you to drive over there and look at those houses if you haven't seen them. We've also funded part of the Housing Authority's works over at some of the renovations on Lincoln and Unity. But certainly Phil Steinhaus and his staff are the folks that really made that happen, but our resources help complement those efforts. And then we also fund Job Point each year with job training. So that's just some of the folks we fund and some of the things we do. I thought it'd be good for folks to kind of get an idea of what our office does. So kind of shifting gears to the needs in our community, and then we'll take a deeper dive into our Fair Housing Task Force. So we've got about 47,000 occupied housing units in Columbia, and close to 13,000 rental households that are what we classify as housing cost burden. Is anyone here not familiar with housing cost burden? If you're not, if a household is paying 30% or more than 30% of their gross monthly income on housing costs, then we classify those households as housing cost burden, meaning you're going to struggle to pay for other things like health care or healthy food, or you might have to defer bills to get by. So it really creates some instability in those households. Of those 12,900, about 7,500 are housing cost burdened at 50% or more. So certainly those numbers are a bit staggering when you think about it. That bottom box shows homelessness. That topic has had a lot of interest as of late. The Functional Zero Task Force by name list shows there's about 288 people on their by name list, so there's a lot of different social service agencies that work on that issue and meet monthly and regularly, and they track people that are homeless by their name, which is really great. And they work to get those folks housed. So last year they housed about 148 people, but they still have about 110 that are classified as chronically homeless, and typically 40 to 50 that are unsheltered. So that's been a need that's been in our community, trending upwards slightly, just like pretty much all of our different needs. So the Fair Housing Task Force came about to help us do an analysis on the front end about the conditions of our community as it relates to housing and access to opportunity to help develop our 5-year consolidated plan. So HUD likes your analysis of fair housing to impediments to be on the front end of your 5-year planning process to make sure you've taken into consideration all those different things. So we're in the process of doing our 5-year consolidated plan, and we should have it complete within the next 90 days. But basically what that is a strategic plan for how we utilize our federal resources. So we create goals tied to a dollar value and match that with how much money we anticipate getting, and really have a process to where the community helps us decide how we utilize those resources. So this is a big hairy slide you might not be able to see, but we will post it if you want to look more closely, and this graphic is on our website. But it kind of shows you the flow of how we're doing our process. So on the bottom left down there, you have our Fair Housing Task Force, which I'll get into a little bit more in depth here in a minute, that we've been working since last July to kind of analyze what's the conditions of our community. And then we're going through our consolidated plan process. We just finished up our public engagement process, and now our Community Development Commission will be analyzing all these different things that we've been looking at, all the different meetings we've had, the Fair Housing Task Force work, and then providing recommendations to council on how we should expend resources for the next 5 years. So a lot of process, a lot of input is what will result in our final product. So this is kind of what our public engagement has looked like. I know I recognize a few people that have been at several of our meetings, but we really tried to have a public process that's also facilitated by members of the public, and I think that's going to provide us a good product with a lot of buy-in at the end. But why don't we shift gears to the Fair Housing Task Force purpose? So we formed the Fair Housing Task Force to do what HUD classifies as a requirement for us to affirmatively further fair housing. So we all know that we have fair housing laws that basically say you can't discriminate certain groups of folks, and you got to abide by the laws as a landlord, as a realtor, or as a governmental agency. But as a part of getting our community development block grant and home funds every year, we have to do more of that. We have to go beyond that. We have to, what they classify as affirmatively further fair housing. So we have to look at the conditions in our community that are present given the history of what's taken place leading up till now, which, decades of different policies and actions have led to where we're at. So we have to look at that and then analyze how do we best utilize our resources to combat some of those patterns that might be leaving some people out or might benefit some people more than the others. That's basically what we've been doing over the last 9 to 12 months or so. So this is how we comply with affirmatively furthering fair housing requirements. We're doing what HUD classifies as an analysis to impediments to fair housing choice. So that's basically, we're doing an analysis to look at what are the conditions of our community and what should we do about it to better those conditions. How do we address disparities in housing? How do we increase access to opportunities such as employment, transportation, neighborhood amenities? How do we replace segregated living patterns? How do we transform racially and ethnically concentrated areas of poverty into areas of opportunity? And then how do we foster and maintain compliance with civil rights and fair housing laws? So that's a really big task. That's a lot to do. In the past, cities have kind of just went through the process and checked the boxes and got it done. Under the Obama administration, they really ramped up what was required and then required you to do it on the front end before you did your 5-year consolidated plan. Now with the new administration, they tried to take away that rule, but that went to court, or the new tool, and so we got put back to where we needed to do this new process called the assessment of fair housing. However, the current administration has now delayed that implementation, but it's not clear if that's going to hold up. So basically, we dove into doing the Fair Housing Task Force, doing more than what was needed under the old process, but being prepared if there's some kind of change in course as things unfold. But nonetheless, I think regardless of what happens outside of that at the federal level, the process we've done is going to add a lot of value to where we end up. So this is our Fair Housing Task Force makeup. Councilman Peters and Trapp were our co-chairpersons and have been a great help with the task force. We also drew from current boards and commissions of different cities' boards and commissions, as well as the Housing Authority, the Board of Realtors, the Apartment Association, NAACP, a lot of different community partners. So we have about 18 people there, so it's a pretty big group. So you get a lot of different perspectives, which is good because it adds a lot of value and durability to the product that we'll have when we're done. So just to give you a little taste of some of the analysis that we were looking at, over the course of about 3 to 4 meetings, we had the group do a collaborative map review analysis. When I did this process 5 years ago, I just did the analysis myself as a staff member, which was okay. But I think what we did this year was a lot more meaningful because we had the community basically do that analysis. So in our report, we basically had about 12 to 15 different maps over the course of 3 to 4 meetings, and we had people get into groups of 3 to 5, walk around to the maps and basically say, what do we see as the fair housing challenge or issue here, and what is its impact? So when we have our final report, you'll truly have a community analysis of what's going on, which I think will add some value. So this map here is African Americans by census block. The red areas are where there's high concentration, blue areas where they're low, and this map shows the central city area. So you can see out to the west there, that's Columbia Square. To the north is Alita Boulevard. One topic that came up quite often throughout our meetings from a variety of members was how the central city area seems to be changing, and that what was traditionally African American neighborhoods seems to be changing a bit. And this map kind of shows a little bit of that occurring. So this is out east of town with a little higher concentrations. This is up north with higher concentrations. And again, I'll have these slides. We'll have them on our website. And if you look to the next map, this is the Southwest, where it's a lot lower concentration of African Americans, mainly white. So another thing that we looked at many different things, everything from location of grocery stores to employment to transportation, schools. We looked at all kinds of stuff. Was something that kept recurring is employment and transportation were really important. So we looked at, you can see the Southwest where there's maybe not a lot of affordable housing or less affordable housing. There's also lacking a little bit of access to employment. So when thinking about where do we place affordable housing, we've got to think of all the different critical decisions and how do we get to an ideal scenario for where we place affordable housing. So this is just an example of the nuances that we discussed as a group and the challenges. So this is employment proximity in the Central City neighborhood. So you can see there's a lot more access to employment. So again, these are just a variety of topics that the group has looked at. One thing I think it's important as a community to think about that seems to blow a lot of people's mind is how much it costs to build housing. And this is really the crux of the issue of housing is costing a lot. The cost to build and construct housing is increasing, and wages aren't keeping up to be able to pay for housing. So how we create affordable housing is funding the gap between whatever household we're trying to serve at whatever income level, funding the gap between what they can afford and what the home needs to sell at or rent at. So we either provide some kind of down payment assistance or subsidy for a home buyer, or some kind of rental voucher if it's a person that's in a rental type situation. So I think it's important to take that context and have that on your mind. So this is just an example of one of the Lynn Street Cottages homes. It cost about $183,000, but we had some additional costs that might not occur on a singular lot. We had some stormwater improvements we needed to take care of because that was a part of our neighborhood engagement process, so we wanted to go above and beyond what was required. So we did a lot of stormwater. We also did solar panels and also tried a new style of development of the cottage housing style development, which we needed to do a little bit additional grading. Because we did get some more density, our lot costs went down. So if we did a singular lot where we didn't have stormwater or solar panels and maybe some of the less grading, we could maybe get that down to around 165. But what's interesting, over the last 2 years, we had this home priced out just a couple weeks ago, and the costs have went up by about 13%. So we've seen a really big increase in materials from, the trade war, as well as some of the rebuilding efforts going on in Florida and Texas, and just an increase in labor and materials. So prices are continuing to rise. One thing I've been trying to stress in a lot of different places where I've presented is, as a community, when we're talking about addressing affordable housing, we need to think of all the different needs and all the different households that are out there, and think of strategies in a comprehensive manner. So there's a lot going on this slide, but each of those bars represents a different income bucket group. The one on the far left is households making $5,000 or less. The one on the far right is $150,000 or more. And how many households fall into those buckets. That's the numbers at the top. So there's about 47,000 households. So you can kind of see here's where all the different income households are in our community. On the bottom, I have the different strategies that we use to help increase mobility for families in our community. So in the blue there, you have home ownership assistance or the Columbia Community Land Trust. So those are about the income households we serve there on those middle bars, all the way from about 25,000 up to 74, depending on how many people are in the household. So if there's less people in the household, the income threshold's lower to qualify. If there's more people in the household, the threshold's higher, according to our HUD guidelines. And we serve about 40-ish people or households per year in that program. Down below there, you have the yellow and the green is all of our public housing, our vouchers, as well as homeless shelters, other voucher programs for people that may be homeless, so your lower income folks. And there's about 2,500 or so opportunities that we can provide to people in those categories. So you can see there's probably about 13,000 households in those categories. So in each of those categories, there's the needs higher, way higher than the resources we have available. But I think it's important when we're thinking about doing strategies for furthering affordable housing, that we don't invest all in just one area. If we all put it on the bottom, then people on the top are going to get pushed down. If we all put it on top, then people aren't going to be able to pull themselves up. So we've got to kind of hit it all across that spectrum, is the point there. So was anyone in the room here at our Fostering Equitable Inclusive Neighborhoods event back in the fall? Andrew was, a few of us. I thought it was really interesting to kind of revisit this. It was a really good presentation from Tiffany Manuel, and her presentation was mainly about how do we frame furthering affordable housing in our community and furthering our community development efforts, getting people on board for why this is a good thing. And some of her key messages were avoid leading with negative data, and I already did that in this presentation, so I broke that rule with showing all the need. She talked about anchoring people in solutions. So going to those slides where I showed Gary up doing the homebuyer classes, the ribbon cutting around the home, so showing the good things that we're doing to get people excited about what we're doing. And then also continuing to have challenging conversations about equity and race, as well as putting people into the future. So when we look at the negative data, we're looking backwards. It gets people to think of a scarcity mindset and kind of shut down and be overwhelmed. But when we talk about what do we want our community to look like in the future, it gets us in a forward-thinking mindset and more excited about what we want to do. So that was kind of her main message and her key takeaways that I had. I found it interesting, back in July when we started the Fair Housing Task Force, I had all the members do a self-assessment, and I think this self-assessment relates directly to Tiffany's comments. So I had them assess what are their values, rating from 1 to 5. And you can see the top 2 values. People really valued addressing disparities in access to opportunity, such as jobs, employment, transportation, and amenities, as well as providing more affordable housing. So no matter your political value set, everybody's behind having more affordable housing near jobs, transportation, and good neighborhood amenities. Everybody can self-identify with that being a good thing. And the thing that scored the lowest was promoting racial integration in neighborhoods. And my interpretation is that people had some uncomfortable with how we worded that, and it could potentially relate to what Tiffany was talking about, of that being looking backward. She stressed it's important to recognize what's happened in the past and where we've gotten things wrong, but when we're talking about solutions, to get everybody on board, we have to be thinking a futuristic mindset. So I think that slide may potentially relate to that. So that was a lot of different information, and it just scratched the surface of what we've covered, but I thought it might be good to open it up for questions if we've got a few minutes. All right. Question?
Okay, so you showed the big section of the chart that doesn't meet where the market rates are, the market price for housing. How do we get more money into the pie that can go to that side of the graph? Like, I know that's kind of everyone's question is how to fund the program, but I'm just throwing that out there. How do we?
Oh, thanks. So yeah, my question is, how do we get the funds that are missing, the ones you showed that aren't there, versus the number of households that need help versus the number of households who are able to get help now?
Yeah, sure. So currently we utilize our federal funds for affordable housing, and they do a good job of providing opportunities, but certainly the need's greater. So there's a variety of different communities that use, like a housing trust fund, use different local funding sources, things like that. So there are other opportunities. I think the challenge in our community is there's a lot of other needs as well. Someone asked me at the Human Rights Commission earlier this week, I did a similar presentation. They asked me, what do you think your biggest challenges for affordable housing are? And no one has asked me that directly in a meeting, and I thought, what's going to come out, you know? And my answer was, after thinking about it, I thought, well, I think the real need before that is infrastructure, particularly in our central city area where we're doing a lot of work. We have a lot of stormwater, sanitary sewer needs. And our next project that we're doing on North 8th, we did 10 homes, but if we would have went to 11 or 12, we wouldn't have been able to do that because that sewer line couldn't have handled the capacity. So I think as a community, you know, there are some additional tools that we could use for affordable housing, but there may be some other stuff we might need to think about doing first. So I think it's, when you're thinking of public policy, we got to think of the full spectrum of needs when we're talking about doing something more.
Follow-up question. Do you see, I don't know how much of a trend this is more recently since the financial meltdown, but do you see people purchasing property as an investment strategy driving up the price of property? Because there's only so much property to go around in the city limits.
Yes, I would see that. I actually crossed paths with our appraiser, Alan Moore, in the alleyway earlier this week. And we were talking about the work we'd done over on Lynn Street and some more things we had in the work. And he was like, yeah, I think that's been really good for the neighborhood. But he said that he's been seeing a lot more private investors going in to invest in those homes and flip them, which is good. It shows where we've invested, the private market will follow. But certainly there is the potential for that displacing some people. So we need both things to happen. So yeah, that's a potential risk. But yeah, it's just a challenge we've got to work through.
My question may be sort of related to that. The work that you're doing, refurbishing the homes and that sort of thing, how are you combating the rise then in the property value around those areas and the potential for now increased rent and increased property values and that sort of thing for the folks that are having trouble affording the housing as it is now?
Yeah, sure. So that was a big part of why we created the Columbia Community Land Trust. So now that we have that organization where we've invested in affordable housing, the Community Land Trust will own the land underneath the homes, allow us to sell that home at a greatly subsidized price, and then protect that subsidy for future buyers. So the way we have it set up with their 99-year ground lease, the first buyer can get, when they go to sell their home, they can get everything they pay down on their first mortgage, right? So say their base price was $100,000, but when they go to sell, they can only capture 25% of the market appreciation. So say that home was valued at $130,000. They bought it for $100,000. We subsidized down to $100,000, and when they go to sell, it increased $10,000 up to $140,000. Our ground lease restricts them to only get 25% of the market appreciation, so they can only sell it for $102,500. So that tool right there is a great way to do it. But certainly we're doing 4 to 5 homes per year. So we're not doing a whole lot of homes, but where we are doing it, we're doing it well, and we're addressing that issue.
I have 2 questions. I have one, how does the Habitat for Humanity fit into this situation?
Yeah. So Habitat for Humanity does a lot of great work. So we fund them annually with all the homes they do pretty much. They go through our down payment assistance program for some of their homes, but then some of them we also fund the construction of. They actually were the first nonprofit, I think, to get a community land trust home done on Lynn Street. And I would expect that we'll work with them more in the future.
And then you said something in your statements about you can sit down and work with someone if your credit is kind of down to try to get you in a proper credit rating.
Yeah.
Could you give me that entity again? I didn't quite.
Yeah, so we actually have an event on June 8th. If anyone in the room is interested or knows someone that might benefit, June 8th at the Second Missionary Baptist Church here downtown. So we have a partnership with Veterans United Lighthouse Program, and basically they do an hour-long credit education class where we talk about what credit is, what the impact of having lower credit is, how to get it up, all the different theory behind it. But then also everyone that attends can bring their own free credit score, and then they bring like 5 different credit counselors, and they'll be on hand to really go through the credit report. Now that's such a big deal because there's so many people in our community that have been struggling to get by for so long that they're in a hole and they have a hard time of seeing their way out. And this is that opportunity to lean into that and get a plan and help get out. And we've had really good results with it. But if you're interested or know someone, June 8th, it's a Saturday morning, we'll have breakfast as well, probably bacon. So be a good draw. Yeah.
you were tracking by demographics, so you had shown the maps for African American where you're living. Do you guys also track like household composition and match, how much of this is, single mothers, just household composition, number of children in the household in comparison to where they're living?
So we haven't mapped that. I do have a couple charts in our report that'll be in there that shows those different household types, but we haven't mapped those specific demographics.
Do you want to touch on the home buyer seminars that you do?
Sure, yeah. So we do those monthly. I think we have one coming up April 16th. But yeah, we do them monthly. Gary Anspaugh does those. He does a great job. We have about 25 to 30 people a month there. But one interesting thing is that's going to change soon because there's a new federal mandate that our classes aren't enough. So we're going to have Gary do direct one-on-one homebuyer education with everyone going through our program, which is going to ramp up his work, but I think it'll be an even better service for the people we serve. So we're currently looking at, do we keep doing that class maybe less times per year and focus all on our one-on-one counseling, because we do get a lot of good turnout at it. So we'll be looking at that and seeing how we're going to handle it.
The homes you've built are all UD, is that correct? Universal design?
So they have universal design features. So the ones that we have in there are the wider doorways, 0-step thresholds. We have blocking in place in the bathrooms. We have one bathroom that has a 6-foot radius turnaround or the T that meets that standard for the bathrooms. And we have lever-type door handles. I think the lever switches. So I don't know personally if there's a kind of a gold standard for UD. I don't think that's been worked out yet, or if it has, I'm not aware of it. But we do have some really important basic universal design features that makes the home very easily to make accessible for a broad cross-section of the population.
And the only other thing I want to say is I know that numbers of housing units are very sexy, and I appreciate the attention that you spend looking at the sewer and the grading and all the stormwater and all of that, which is important for most of us, but sometimes not always looked at as the sexy part of housing.
Oh, thank you. Stormwater can be sexy. Yeah. All right. Any more questions? That's a good place to end. Yeah.
If anybody wants to go down to Acme Shirts and get Stormwater is Sexy on a shirt for Randy, I'm happy to chip in over lunch. They can get it done in half an hour. So thank you, Randy, for the presentation. I think that's the third time I've heard it, and I still take new things away. So I'm really grateful for all of that data. I think it's important for us to use data in every decision that we're making, because otherwise we're making those decisions in the dark. So thank you. Our next speaker is Eric Krekel. Am I saying that right? All right, fabulous. Eric's been employed with the Missouri Commission on Human Rights for 37 years. He began his career with MCHR as an investigator in the Kansas City office and currently serves as Director of Investigative Operations in the Jefferson City office. He oversees agency operations statewide, assists in program development, strategic and budget planning, and acts as a liaison with the Missouri Attorney General's Office, the U.S. Equal Employment Opportunity Commission, and the U.S. Department of Housing and Urban Development. In addition to providing initial training to the MCHR's investigators, he provides education, training, and outreach to other state agencies and to the public. Eric received his bachelor's degree in sociology from the University of Missouri at Kansas City. He earned his master's in public administration from the University of Missouri-Columbia. There's a lot of us in this room with that. Let's welcome Eric Krekel. Thank you.
Good morning, everybody. All right, that was actually an old resume that they had. I'm up to 40 years now with the commission. So, there you go, yeah. Time flies when you're having a good time, right? So, all right, we've got a disclaimer from our attorneys here. We don't want to use this as legal advice, and if you need to, you should consult with your counsel about this information. Our objectives here today are to give some background and history about the Missouri Human Rights Act, talk about the administrative complaint process that the Act provides for, and deal with what is covered under the fair housing sections of the Missouri Human Rights Act and the changes that were made to those fair housing sections by Senate Bill 43, which became effective on August 28, 2017. And I'll kind of describe what our current housing situation is and question and answers. So this is a copy of the ordinance abolishing slavery in Missouri. This was the state's first anti-discrimination law. The document is from the 1865 Constitutional Convention, and as a cool aside, it was signed by my great-great-uncle, or great-great-great-uncle Arnold Krekel, who was president of that Constitutional Convention. So that was pretty cool to find out. When he signed that ordinance, it freed over 100,000 people who had been previously enslaved in the state of Missouri. And this was passed, this became law 11 months before the U.S. Congress amended the U.S. Constitution and passed the 13th Amendment. So Missouri was actually ahead of the curve on that one. Interestingly, you can see along the edges this was burned because the first Capitol building down in Jeff City burned down in 1911. Many documents were lost, and this one was literally snatched from the flames. Other way. All right, fast forward 90 years to 1957, 1958. This is a picture of our first commissioners, the first commission, Missouri Commission on Human Rights. When this was created, the commission had no enforcement powers. It was simply to encourage fair treatment and foster mutual understanding. So it had no enforcement power whatsoever. In 1961, the legislature passed the Fair Employment Practices Act, which prohibited discrimination because of race, creed, color, religion, and national origin in employment. It gave us enforcement power there. In 65, the legislature passed the Public Accommodations Law, which prohibited discrimination because of those same protected categories in places of public accommodations. And it wasn't until 1972 that the legislature passed the Fair Housing Act here in Missouri. Later, sex and handicap were added as protected categories under these three separate laws. And in 1986, they were all combined together into the Missouri Human Rights Act. Handicap was changed to disability in that law, and complainants were also given the right to sue. So if they wanted to not go through the administrative complaint process, they could request what's called a right to sue letter. We'd close our case, and they could take their case into court themselves, but they'd have to get an attorney to do that. We've got some interesting people who were our first commissioners. The woman there is Lucille Bluford. And Lucille Bluford was a lifelong civil rights advocate and journalist, editor, and publisher. And in 1939, she'd just gotten her bachelor's degree in journalism and applied to MU to go to their master's in journalism program. And she was accepted. She showed up to enroll, and they said, well, you can't come here, you're black. And so she sued them. And her case went up to the U.S. Supreme Court. And the standard they were looking at in 1939 was very different from what it is today. They were looking at a separate but equal standard because segregation ruled. And so they basically said, well, if the black university offers a journalism, master's in journalism, then she's going to have to go there. But Lincoln University did not offer a graduate program in journalism. So they said to MU, well, you're going to have to let her in. So what did MU do? They eliminated their graduate program in journalism. So that was in 1941. So undaunted, she became a reporter and was working for the Kansas City Call, became the editor of the Kansas City Call and the publisher of the Kansas City Call. The newspaper is still in existence today. In 1984, MU awarded her a Distinguished Medal of Journalism, and in 1989, they gave her an honorary doctorate degree. So it only took her 50 years, but she got her graduate degree from MU. And the gentleman behind her on the left there has a famous or infamous grandson, however you look at it these days. His name was Rush Limbaugh Sr. Yeah, indeed. So today, the Commission on Human Rights mission is to prevent and eliminate discrimination. We try and prevent discrimination by doing education, training, and outreach, and we try to eliminate it through enforcement of the Missouri Human Rights Act. The statute provides that we can have 11 commissioners, one for every congressional district and 3 at large. But unfortunately, currently, we only have 5. So we don't have a quorum to carry on official business. Melody Smith is the acting chairperson. She's from St. Joseph. Anna Crossland is from St. Louis. Donna Burks from Kansas City. Jade Jump from Southwest Missouri. And Dr. David Thomas is from here in Columbia. So if any of you want to become a commissioner or know somebody who does, the governor's office takes applications for that, and their boards and commissions office. We do have a federal partner, the U.S. Equal Employment Opportunity Commission. After Senate Bill 43 was passed and became effective, EEOC determined that while there were some differences or some more differences between the Missouri Human Rights Act and the federal laws that EEOC enforces, they determined that we were still substantially equivalent. And so they continued to have our work sharing agreement whereby somebody files a complaint with us, it's automatically filed with the EEOC or vice versa. So it can be one-stop shopping to protect both your federal and state rights. So if they file at the EEOC, it's also filed with us. We divide up this common workload so that EEOC will investigate the complaints that they take. We'll investigate the complaints we take. We'll inform the other agency of the finding, and we usually adopt the other agency's finding. So it's an efficient use of our scarce resources, and the best part is that it brings in federal money because they pay us for investigating those cases. So it's a good relationship. However, HUD determined after Senate Bill 43 was passed that we were no longer substantially equivalent because we were not identical to the Federal Fair Housing Act. So to them, substantially equivalent would mean identical. So what has changed under the Missouri Human Rights Act, under the Fair Housing sections, and what has remained the same? So our protected categories mostly have remained the same. We still cover race, color, religion, national origin, ancestry, sex. So ancestry, well, national origin is literally somebody's country of origin. And ancestry is going to be somebody who was born in the United States that has the physical, cultural, or linguistic characteristics of a national origin group, like Latinos, Asian Americans, etc. Now, sex discrimination covers gender discrimination, sexual harassment, and pregnancy discrimination. And in terms of religion, the employers do have the obligation to reasonably accommodate the religious obligations of their employees, but it doesn't have to create an undue hardship on the business. All right, age is protected from discrimination, but only in employment. Familial status is protected from discrimination only in housing. Familial status is the status of having custody of minor children. So landlords cannot discriminate against somebody because they have children. Now, they can still have to follow the city or the county's occupancy codes, but they can't have anything stricter than those occupancy codes. It's been on the books here with the commission since 1992, and it's been part of the federal law since 1988, but some small landlords still do not realize that it's against the law to discriminate against people because they have children. Not too long ago, we had a case where the landlord was trying to rent this small house, and he put a sign in the front yard that said, "No pets, no kids." Gave a number to call, and you call the number, and he's just got his answering machine going, and he wants to get your contact information, and he reiterates, "Nope, no pets, no kids." So that one was hard to investigate. Took a picture of the sign, recorded the phone message, and his denial that he did that was not very credible. So
Can you discriminate against pets?
Pets, yes, but not assistance animals, and we will talk about that too. So now retaliation is also protected, but only for certain protected activities. So there are some activities that are protected by the Missouri Human Rights Act from retaliation. One of those is filing a discrimination complaint with us or even internally is protected from discrimination. Assisting in the investigation or processing of a discrimination complaint, you can't retaliate against people for doing that, or for opposing a discriminatory practice. Now, the bad thing from Senate Bill 43 occurred here because they excluded housing complaints from retaliation protection. So I don't think they planned on doing it, but it was a drafting error or something. But the result is that there is no retaliation protection for housing complainants when they file a complaint with us under the state law. It also wrote out of protection for housing complainants association discrimination. And that's where someone would discriminate against you because of your association with somebody in a different protected category. An example of that would be race and race association, where you've got a mixed race couple, maybe they're applying for an apartment and everything's going fine. When the white spouse is there, the black spouse shows up, and all of a sudden there's problems with the application or something. So now we no longer cover that because that got written out of the statute. So what transactions are going to be subject to the Fair Housing statute or sections in the Missouri Human Rights Act? It covers the sale, rental, financing of housing, and also the design and construction of multifamily dwellings. So the fair housing sections of the Act cover the entire relationship between a housing provider and an applicant or tenant, from the initial inquiry through application, tenancy to termination, move out, and sometimes beyond. So during that time, any transaction or interaction could give rise to a claim of discrimination, because this is going to cover all the terms, conditions, and privileges of sale or rental of a dwelling. Discriminatory housing advertising is also prohibited by the statute. Design and construction requirements are passed for multifamily dwelling to provide a minimum level of accessibility. Okay, so there are some exemptions when it comes to sale of houses. And the exemption applies to single-family homes, the sale of that, if it's owned by an individual, not a company, and that individual has no more than 3 single-family homes. And, this is the kicker, and they do not advertise. If they put a sign in the front yard, they're covered by the statute. If they put an ad in Craigslist, they're covered by the statute. This is a little more stricter than in the federal fair housing law. Their provision there is that they don't discriminatorily advertise. Okay, exemptions where it comes to rental would be an apartment building with no more than 4 units and the owner lives in one of those units. Then that unit is going to be exempt from coverage of the law. Housing for older persons can be exempted from familial status discrimination, but at least one occupant in every apartment has to be 55 or older, and 80% of the units in that complex, and they have to have facilities and policies specifically designed for older persons. So in other words, this can't be just a sham to not have to rent to families with children, because landlords do like to do that. Okay, who must comply with the fair housing sections of the Human Rights Act? Well, anyone who has control over residential property or financing, that could include landlords, rental managers, property managers, real estate agents, bankers, architects, developers, builders, and there can be individual liability. So typically you would, if it's a rental situation, you would name the apartment complex, the owner of the complex. If there's a management company, you'd name them and the rental manager at the apartment complex. And if they're found guilty, the individual could have individual liability. Disability discrimination in housing. The law provides for equal access to housing, so facilities that are physically accessible. The law also provides that landlords, housing providers must make reasonable accommodations and or modifications to a person with a disability. And then the design and construction requirements there too. Providers must make reasonable accommodations in the rules, the policies, the practices, or services when necessary to afford a person with a disability equal access to services, programs, or activities. Like in the Americans with Disabilities Act, there has to be an interactive process regarding reasonable accommodation between the applicant or the tenant and the housing provider. Now, reasonable architectural modifications to a dwelling have to be allowed at the expense of the tenant. And an example of this would be, gee, I want to install a grab bar in the bathroom. So reasonable modifications have to be allowed at the expense of the tenant. And so like the Federal Fair Housing Act, the Missouri Human Rights Act provides multifamily dwellings that were built after March 13th, 1991, to have features that make them accessible to people with disabilities. Okay, reasonable accommodations. Individuals with a disability need to make a request for a reasonable accommodation. The request doesn't have to be in writing, and it doesn't have to use the magic words reasonable accommodation, but they must communicate that they need some modification because of their disability. So a reasonable accommodation should be granted if the person is a person with a disability, and is reasonable and necessary to ensure their equal access to this housing opportunity. These have to be analyzed on a case-by-case basis, as they're very much fact-dependent. Now, one reasonable accommodation would be allowing someone to have an assistance animal. Now, assistance animals are different from service animals or service dogs under the ADA. There's a more restrictive definition for service dogs or service animals under the ADA. In the housing sections, there is a little more expansive definition there in coverage. MCHR, the Commission on Human Rights, has always followed HUD's lead on what is allowed with assistance animals, and that's why HUD calls them assistance animals rather than service animals, to avoid confusion there. There are going to be animals that provide a service or assist somebody with a disability or provide emotional support that improves the symptoms of a disability. Examples would be a seizure alert dog, maybe a cat that reduces a person's anxiety or depression. Important point is that assistance animals are not pets. And landlords seem to have trouble with that concept. And we'll find that people want to charge a pet deposit or a monthly pet rental fee in addition to the regular rent there. And service or assistance animal is not a pet. So none of those things apply. Even if they have a no pet policy, it doesn't apply to assistance animal because they're not a pet. They provide assistance to a person with a disability. So the landlord, the housing provider, can ask for some reliable information or documentation about the disability and the need for the assistance animal. And the documentation could come from a physician, a psychiatrist, a social worker, or other mental health professionals that the animal provides emotional support that alleviates one or more of their identified symptoms of their disability. Request for reasonable accommodation cannot be unreasonably denied or conditioned on the payment of a fee or a deposit, and a response to such a request cannot be unreasonably delayed. And we have a case in court currently where the landlord would just never get back with the complainant about their request to have a service animal. Such a delay in responding or no response is effectively a denial of the request for that accommodation. Okay, unlike the ADA, in the housing sections and the Federal Fair Housing Act, assistance animals are not limited to dogs. They're not limited to dogs. So you can have quite a wide variety of assistance animals. We had one case where the assistance animal was a guinea pig. And why would the landlord say no to a guinea pig? What, you want to have a large dog in the apartment instead? So anyway, you can get some strange ones there. There was one case with a service or assistance boa constrictor. So you never know there. Animal does not require specific training like it does under the ADA. The animal can accompany the tenant in all of the common public areas of the apartment complex. And like I said before, you cannot charge for additional stuff there. The person with the disability should get some kind of documentation from a therapist, social worker, a doctor that verifies they have a disability and describes how the animal will ameliorate the effects of that disability. The documentation doesn't necessarily have to identify the specific disability, but has to indicate that the person does indeed have one. Okay, and this is interesting too, that the type of animal, is also exempted from restrictions there. Sometimes, we get some complex issues where you're dealing with multiple animals, So they got a doctor statement says Mrs. Smith needs her 2 dogs and 3 cats to help with her depression or something like that. So can raise some interesting issues. Currently, in the Missouri House and Senate, there are bills that would change the definition of service and assistance animals. These bills proposed would criminalize the misrepresentation of a dog as a service or assistance dog for the purpose of receiving accommodations available under the ADA or the Fair Housing Act. So violation of this would be a Class C misdemeanor. Any subsequent violations would be Class B misdemeanors. Both bills have been voted out of committee, and the House bill has actually been perfected. So it could go on a calendar soon. Those bills were introduced last year, so they probably have a better chance of passing this year. Reasonable modifications. So Reasonable modifications basically permit the complainants to reasonably modify existing premises at their own expense. But if the property is a recipient of federal funds, then the landlord's going to have to pay for that. Housing accessibility requirements. The Human Rights Act requires multifamily dwellings to be designed and constructed to allow people with disabilities access, and it provides, a minimum standard of accessibility. There are 7 basic requirements for accessibility, basically requiring it to be an accessible route into the apartment building and into and throughout the apartments, including the kitchen and the bathroom. Environmental controls and light switches have to be where someone could reach them from a wheelchair, as some examples of the accessibility requirements. A lot of people have ignored those accessibility requirements in the federal law and the state law. And there's a provision in the Missouri Human Rights Act that allows the Attorney General's office to file suit in court if there is an issue of general public interest. And so a number of years ago, the AG's office filed design and construction complaints in court against some condominiums and apartment buildings at the Lake of the Ozarks. And they filed against the architects and the designers and the builders and the owners and the developers. So these were really large lawsuits. And they had completely ignored the accessibility requirements. So, a tape measure is not going to lie, was this door wide enough for a wheelchair to go through there or not? So there's some very expensive litigation and then retrofitting of all those apartment buildings down there. But the AG's office was trying to send a message to architects, designers, builders, that they have to comply with those accessibility standards when they're designing multifamily dwellings. So this is kind of a breakdown of the complaint allegations that the Commission received in fiscal year 2018. So it's pretty amazing that almost 43% of the complaints we received alleged that they'd been retaliated against. So they thought they were being retaliated against for filing a discrimination complaint or assisting in the investigation of a discrimination complaint, or because they opposed a discriminatory practice. Now we get, some no jurisdiction situations with retaliation when somebody says, well, they fired me because I filed for workers' compensation. That's not going to be protected. But still, 43% is very large. 36% of the complaints received alleged sex discrimination, 34% disability, 28% race, and 16% age discrimination. So those are our big 5. National origin, religion are, single-digit areas there. The reason this adds up to more than 100% is because we get multiple allegations per complaint. So we might get a complaint of sexual harassment, and somebody says, then I filed an internal complaint about that, and they fired me in retaliation. So we have a sex discrimination complaint and a retaliation complaint all together. Or you could get a complaint of disability and age discrimination, or race and sex discrimination, multiple combinations there. 84% of the complaints we received last year were employment cases. We got a total of 1,706 complaints, so that's a lot of cases for a little old agency like the Commission on Human Rights. Housing cases, number went down again, so it was down to 84, only 5% of our caseload, and public accommodations was about 11%. Okay, our complaint determinations. 35 Yeah, 35% of the determinations of cases were closed when a complainant requested notice of their right to sue. They got an attorney and they wanted to go to court. So we closed their case, gave them their right to sue, and they were able to go sue in court. So that's a lot. That's over a third of the cases where somebody wants to litigate it. We found no probable cause in 36% of the cases. We settled almost 8% of the cases. We found probable cause in 1%, and almost 20% were other kinds of administrative closures. So that 1% probable cause rate looks low, but consider that the strongest cases are either going to settle because, we already got the goods on these people. So they're going to settle. They know they need to get this resolved or it's only going to get worse, or they're going to get an attorney and go to court and see if they can get even more there. So our best cases settle or get the right to sue. So if you combine all three of those percentages together, you get what I call a merit rate for 44%. So that sounds a little bit better. So anybody who believes they've been discriminated against can file a complaint of discrimination. The statutory language is any person claiming to be aggrieved may make, sign, and file a complaint. With us, we've got 180 days from the alleged discrimination in which to file. So if you file on the 181st day, we do not have jurisdiction. So EEOC's got a 300-day filing period, and HUD has got a 1-year filing period under the Federal Fair Housing Act. Okay, the complaint process under the Human Rights Act is essentially a 4-part process. We've got intake, investigation, conciliation, and public hearing. The case only goes to conciliation if we find probable cause. So small percentage go to conciliation, and a smaller percentage go to a public hearing. So most of our activity is going to be at the intake and investigation stage. So intake basically is where somebody contacts the commission and says, hey, my human rights have been violated. Well, human rights and what everybody thinks are human rights are very broad, but our jurisdiction is very specific. Our jurisdiction is over housing, employment, and places of public accommodations due to the protected categories, race, color, religion, national origin, et cetera. So intake people basically try and screen out the things we do and do not have jurisdiction over. We'll try and refer people to the appropriate agency when we don't have jurisdiction, and when we do, our intake staff will fill out a complaint form for the complainant's signature. They have to check timeliness, they have to check jurisdiction over the respondent, they have to check subject matter jurisdiction, and does the complainant have standing to file? Have they actually themselves been aggrieved by the complaint? A husband cannot file a complaint for his wife. If she's aggrieved, then she has to file that complaint. So investigation is where we gather information to determine the validity of those allegations. So because we don't know whether or not there's been a violation of the statute, MCHR acts as a neutral fact finder during the investigation. So we do not represent the complainant or the respondent. And sometimes we have to remind both of them of that fact. Complainants think, well, you're the Commission on Human Rights, you're supposed to help me. Well, right now we're trying to determine whether or not there's been a violation. If there has been a violation, then that's a different story. But right now, we're just trying to make a determination about what happened here. Was it against the law or not? And sometimes respondents, when we try and investigate these complaints, think we're the complainant's advocate and, get an attitude. So we have to explain, no. Statute says we have to investigate, so we're just doing that. We don't represent the complainant or you. We just need to get the facts and the evidence to make a determination about the validity of these allegations. So, after the investigation, the investigator writes up the case, makes a recommendation, the executive director makes a finding, and she might find that there was no probable cause. And if that's the case, then we're going to close the case. And the option right now for the complainant is to appeal that finding. Before the changes in Senate Bill 43 that were effective in 2017, we would find no probable cause and give the complainant their right to sue. So we can no longer do that. For pre-8/28/17 allegations, when the evidence obtained did not establish a violation, we would close the case but give them the right to sue. Now their only option is to appeal our finding, which means suing us in court, and they do. So, but the right to sue section in the statute indicates that after 180 days, if we haven't finished our processing of the complainant requests notice of their right to sue, then we'll give it to them and close our case. They have 90 days to file suit in court, or they lose that right to sue. There's a 2-year statute of limitations on the right to sue, which means that somebody has to file suit within 2 years of the alleged discrimination or its reasonable discovery. And we're still getting a high number of right to sues. You know, that 35% is pretty high. Now, if we would happen to find probable cause, then the case would go to conciliation. And we've got the finding that there was discrimination from our investigation to use as leverage in terms of trying to settle the case. And we can't force people to settle, but if it does conciliate, then we sign a settlement agreement, we monitor compliance with the terms of the agreement, but we can't force people to settle. If they don't want to settle, then our chairperson decides whether or not to set that case for a public hearing. If she does not, then we dismiss the case, and if it does go to a public hearing, we're going to have a case heard before the Administrative Hearing Commission of the state. So it's an administrative law proceeding, but it looks just like a case in court. And instead of a judge, we have a hearing examiner, and we have an assistant attorney general who's prosecuting our case for us. And so they hear all the evidence. The hearing examiner makes a recommended finding that goes to a panel of 3 of our commissioners who find whether or not there was discrimination. If they find no discrimination, they dismiss the case. If they find there was discrimination, they will order that to cease and desist, and they will order the appropriate remedy for the complainant. They can order the complainant reinstated into a job, given back pay with interest. They can also compensate the complainant for pain, suffering, humiliation, and deprivation of human rights. One of the largest awards that we've given was in a housing discrimination complaint, and that was for $300,000. So that's definitely significant. All right, here's an example of a case that last year finally came to an end. It took a very long time because the respondent kept appealing. So this was disability failure to rent case. They were denied a reasonable accommodation or modification. Scott and Jacqueline Henderson went to look at an apartment at the Villa Roma Apartments, and Jacqueline had been in a car wreck a few years before this, and so she was in a wheelchair. She had to use a wheelchair. And they liked the apartments. There was one vacant, but she couldn't get her wheelchair over this little threshold to get into the building. So they requested that they put in a ramp, and they would not put in the ramp. So it was just going to be a small ramp, and so the Hendersons said, well, tell you what, how about if we put it in at our expense? And they still would not let them do that. So they filed a complaint. We investigated. We found that they were denied a reasonable accommodation or modification. We tried to conciliate. They wouldn't hear us settling, and so we went to a public hearing, which found discrimination, ordered them to be paid $5,000 in damages, and they were assessed a civil penalty to vindicate the public interest of $2,000. They appealed that to the court, or the circuit court. Circuit court upheld our decision. They go to the appeals court. They upheld our decision. They tried to get it transferred to the Supreme Court, but they wouldn't take it. So finally, complainants got their check. But, you know, that was one that took forever. The disability complaint that I mentioned in terms of the record amount there of $300,000. It was two people who were mobility impaired, and they lived in an apartment. And they used, electric wheelchair scooters and stuff to get around. They could drive the scooter from the apartment into their van because they had a ramp that they put in there. They were on the ground floor. And so everything's going fine until the apartment complex got sold. And the new owners decided they didn't like that ramp. And so they took the ramp down. And so complainant's son came over and took it out of the trash and reinstalled it. And so that upset the new landlords and the managers, and so they took it down again and made it so that they couldn't reinstall it. And so our complainants are trapped in their apartment. They have to have relatives bring them groceries, and they miss, doctor's appointments, and so they had to move. And so they filed a complaint. We investigated, found probable cause. They wouldn't conciliate. We go to public hearing. And one thing with housing cases is they can opt to skip the public hearing and have the case heard in circuit court. And they did that in this case. And the court ruled that, this was pretty egregious discrimination. So he awarded each of the two complainants $50,000 in damages. But then he assessed a fine of punitive damages of $100,000 for each complainant against the respondent. So they each were awarded $150,000 in that situation. All right, Senate Bill 43, the changes to the Missouri Human Rights Act. It instituted a higher standard of proof, so it made it harder to prove cases of discrimination. So before Senate Bill 43, the standard of proof was if you can show that your protected category was a contributing factor in this adverse act. It was, say, my race was a contributing factor to me getting fired, or my sex was a contributing factor to me not getting hired. Okay, then you're going to prevail. A contributing factor. And so the new standard of proof was the motivating factor. So the and motivating, much higher standard, making it harder to prove cases of discrimination. It also eliminated disparate impact or adverse impact cases, which are cases that prove discrimination through statistics. They're practices that are fair, informed, but discriminatory in effect. So motivation is irrelevant in those statistical cases. And when you define, like they did, discrimination, the standard of proof in terms of motivation, it eliminates disparate impact cases. And I also indicated earlier that retaliation and association were no longer covered for housing complainants. And it also excluded individuals that supervisor and manager employees involved there. Okay, it also put caps on damages. So a prevailing complainant who's gotten a right to sue goes to court, they win. It puts caps on the damages that the court can award to a victim of discrimination because there were no caps before. And so the caps basically depend on the number of employees that the respondent had. So they range from 50,000 maximum that you can get when an employer has 6 to 99 employees to $500,000 for the largest employers, that have over 500 employees. So we had a Court of Appeals case in the Western District, Bram versus AT&T, and it ruled that the provisions in Senate Bill 43 are not retroactive. So that means for cases that have discrimination that occurred before August 28, 2017, the provisions of the old statute apply. And so that's important for those old cases. They can still get the right to sue when we find no probable cause, et cetera, et cetera. There are no caps on damages, things like that, the lower standard of proof. But because of those changes, HUD said, hey, you're no longer substantially equivalent to the Federal Fair Housing Act. And so that meant that we lost our contract with HUD. We can't dual file cases with them. Our last full contract with HUD paid $500,000. And it contributed to our expense in equipment and administrative costs, and basically paid for 7 staff people. So those 7 positions have been eliminated. Now, so far we've been lucky, and attrition, retirements, and combining positions, we haven't had to lay anybody off yet. So, but as complainants now they file complaints, they could file with MCHR and with HUD, so there could be some duplication of effort going on there. And we've also found that the number of housing cases that are filed with the commission are really going down. We had 174 cases, housing cases in 2017, 84 in 2018, and so far this year we've only had 10. And I think when a prospective complainant finds out that there's a higher standard of proof and they can retaliate against me for filing this, they're going to choose to go to HUD because they get the retaliation protection there and, a different standard of proof. So we'll see how that works out. We're going to hopefully meet with HUD and see if there's some way we can ameliorate that situation. Now, the Commission on Human Rights is part of the State Department of Labor and Industrial Relations, and we try to get the state and workers and employers working better together. We've got a lot of divisions in the Department of Labor besides the Commission on Human Rights. Division of Employment Security is the largest one. They handle unemployment, insurance and taxes, but they've got a shared work program that not a lot of folks know about, and it's kind of an alternative to layoffs. So instead of laying somebody off and keeping one person, you could split the layoff between the 2 people, and they could work part-time and collect part-time unemployment benefits. So that can be a good service there. Employment Security is also very willing to help people classify their workers properly. Is this person an employee or an independent contractor? And that can be an important determination. The Division of Workers' Compensation, or the Division of Labor Standards, offers safety consultations on site. So they'll look over people's work sites to see if there are any workplace hazards that could result in an OSHA fine, and they'll help the employer take care of that so that they don't end up getting fined by OSHA. Here's some contact information for the commission, if you ever need that. And I wanted to thank you, and I'm here if you got any questions. Questions? Okay, thank you.
All right, let's give one more round of applause really quickly for Mr. Krekel. Fabulous. It's always good to see what the Commission on Human Rights is doing at the state level and verify that we locally are doing very similar things. We're on the same page. That's always good. Our next speaker is Professor Rigel Oliveri. Did I say it right? Fabulous. All right. Professor Oliveri is a nationally recognized expert on fair housing law. Her scholarship focuses on housing discrimination, residential segregation, zoning and property rights, and sexual harassment. Her published work has appeared in a number of law journals and a recent book on the Fair Housing Act. She teaches fair housing, constitutional law, which will happen after this, teaching a class this afternoon, employment discrimination, and civil procedure. She is currently serving as a commissioner on the Columbia Housing Authority Board. Prior to joining the faculty at the University of Missouri, Professor Oliveri served as a trial attorney with the U.S. Department of Justice through the Honors Graduate Program. She practiced in the Civil Rights Division, Housing and Civil Enforcement section. She litigated and tried a number of significant cases involving housing discrimination and sexual harassment in housing. In 2003, she was awarded a special commendation from the Attorney General for outstanding service. Professor Oliveri attended Stanford Law School, from which she graduated with honors. Thank you.
Thank you for that introduction, and thank you all for coming. I do this every year, and I really enjoy it a lot. Last year was the 50th anniversary of the Fair Housing Act, so that was very exciting because it seemed like, we got sort of an extra bit of interest. But really, every year is important for fair housing. And so this is the 51st anniversary, but it's just as important as it was last year. I also really, my goal here today will be to talk about sort of the federal law. I know Eric spoke to you all about sort of the state law and the state process. I'll talk about the federal law, and I'll also talk about some recent developments that are important for the fair housing community. I realize I need to get my PowerPoint started. Okay. So yes, I teach fair housing law. I've practiced fair housing law. I think it's incredibly important, obviously, and I love to come and talk about it really to anybody. So April being Fair Housing Month, I get to talk about it a lot. And I don't want to repeat everything that Eric said, so I'm going to try to talk about the national focus and, like I said, then some new developments. So first of all, when we talk about housing discrimination, we're talking about a lot of things. Fair housing law really encompasses many, many kinds of exclusionary behaviors. Just from the strictest sense of sort of a person discriminating against another person in housing, which is the most basic, Someone is told, no, you can't rent here. Someone is evicted on the basis of a discriminatory motive. There have been filed just with federal, state, or private fair housing groups that use federal money to handle fair housing cases. In 2017, which is the most recent year that we've got data for, close to 29,000 complaints. Now, that's not every complaint because this doesn't capture people who just happen to hire their own lawyer and file a case in court, either in state or federal court. This is just sort of the organizations, the governmental and sort of the private nonprofit organizations that handle these cases. But of course, we know that this is nowhere close to the actual amount of housing discrimination that occurs. And by all estimates, using testing and other data methods, the folks at the National Fair Housing Alliance, who are kind of the premier organization for keeping this information, estimate that there's about 4 million instances of housing discrimination that occur in the United States every year. Obviously, it's a not precise number, but that's their estimate, and that's pretty significant. Why the huge disparity between those numbers? Well, a lot of people don't know if they are the victim of housing discrimination. If someone goes to rent an apartment or put an offer in on a house, and they get told, no, sorry, it's been sold, it's not available, what have you, they may have no idea why. They may not realize that it was motivated by a discriminatory purpose. So it's hard to see, sometimes it's hard to find. And then even when people do experience housing discrimination, they may not know what to do about it, who to complain to, where to go to. So one of the important things about forums like this is to get the word out, to help people know there are places you can go, you can report this. There's places like the Missouri Human Rights Commission and other groups. So just getting the word out is an important step, and it's something I'll talk about a little later too. Okay, so I won't go over too much of the same things that Eric did. I'll just talk about briefly the federal statute, the Federal Fair Housing Act, which was passed in 1968 and substantially amended in 1988, covers the same protected characteristics that the Missouri state statute does. And so that's race and color, national origin, religion, sex. Disability and family status were added in 1988 to the federal statute. The original statute had the first three. Sex actually got added in 1972, and then disability and familial status got added in 1988. One thing that's kind of interesting about the Federal Fair Housing Act, The Americans with Disabilities Act didn't get passed till 1990. So the Fair Housing Act was really the first major federal statute that applies, nationwide to have a disability provision. There are, and then familial status, I know Eric covered this, but that's protects people with children, people who have custody of children, their own children, foster children, what have you. That was also a fairly unique addition to the law. There other civil rights statutes don't contain that protection. And it was put in there because it became pretty clear that families with children were being discriminated against pervasively in the rental housing market, and they were having a hard time sometimes finding apartments to take a family with children. Landlords, were fairly frequently having kind of no kids policies, or you can only have one kid or something like that. So it was a significant problem, and Congress became aware of that and added that to the Fair Housing Act as well. Those are kind of the baseline protected characteristics. The federal law protects those. States and municipalities can add to those if they want. Many states have, and many municipalities have kind of within their own statutes. So the City of Columbia has added a number of characteristics: sexual orientation, gender identity or expression, marital status, status as a victim of domestic violence or having an order of protection, and receipt of government assistance. So those would be protected characteristics, but only kind of within Columbia's municipal enforcement authority. So it would not be, it would not be a violation of federal law for a landlord to discriminate against somebody because of their sexual orientation, nor would it be a violation of state law. And I'm going to talk about some of those characteristics in a minute, because there's been some activity in these areas. But before I move on off of this slide, I put the percentage numbers of the complaints that are filed every year based on the protected characteristic. So if you take a look at that, disability is far and away the most commonly complained of sort of discrimination. In housing, at least. I think there are a couple of reasons for that. One of which is, there's the population of people who are disabled is increasing as our population ages. That in and of itself, people may, have mobility impairments that they didn't have before, or illnesses or conditions that, come with age. So that's sort of the aging of the baby boomers has been one thing. Another thing that I believe contributes to the fact that disability discrimination is the most common thing complained of is that it is somewhat easier to see. Because, as Eric talked about, part of the claim that you can make for disability discrimination is failure to reasonably accommodate or failure to design and construct buildings that meet certain codes. That's actually something that you can observe and see, and so it's a lot easier sometimes to spot those complaints. You still have to obviously prove them, and there's various barriers to people knowing where to complain and things like that. But I think the disability cases just are sometimes easier for people to recognize what's going on. And then we see race, which is sort of the what the Fair Housing Act was first passed for. Still 20% of the cases today are race or color. Probably the next one that I am, familial status is also a somewhat common one. It's 9%, but I suspect that the numbers for that would be higher if more people knew that it was illegal to discriminate on that basis. I've had clients and people tell me that they didn't realize it was illegal. They say, "Oh yeah, I had a landlord say he wouldn't rent to me because I had 2 kids." And I'd say, "Well, that's illegal. You could complain." So I think even the population of people who are affected may not know that that's against the law. Certainly for a period of time, landlords didn't seem to realize that was against the law. And so kind of in the 90s and the 2000s, we had a lot of cases where landlords would state allowed, I'm not going to rent to you because you have children, and not realizing that they were violating the law. So those were easy cases to win. But I think that the message has gotten out now, at least to the sort of landlords and real estate professionals, and they know that that's now prohibited. And then finally, sex is not, 7% of the complaints were based on sex discrimination. And I'll talk a little bit more about that, because you don't see as often cases where someone is being told, oh, you're a woman, I'm not going to rent to you, or you're a man, I won't rent to you, or something like that. That happens. It definitely does, but it's not as common of a presentation. The much more common thing that we see in housing is that female tenants are sexually harassed by landlords, and that is considered a form of sex discrimination. It's considered discrimination in the terms and conditions of their housing, and that is a significant problem. It is not reported nearly enough. Again, many people who experience it don't recognize that it's actually a violation of federal law or state law. Many people who experience this are kind of low-income people whose housing isn't exactly stable to begin with, and usually their problem is more trying to make sure they have some stable, decent housing. And that's their primary concern. And if they have a landlord who's also harassing them, that's terrible, but often something that women are willing to endure because they don't want to lose their housing or jeopardize their housing. So I'll talk about that more with some new developments that are coming. Okay, so I will just very quickly, the Fair Housing Act prohibits the same things. The Federal Fair Housing Act and the State Human Rights Act prohibit the same kinds of discriminatory behavior. It prohibits making housing unavailable or denying housing based on a protected characteristic. So evicting, refusing to rent, refusing to sell, something like that. It prohibits different terms and conditions in housing. Like I said, that could be harassment. Exposing someone to harassment, or forcing someone to endure harassment, is a type of term and condition of housing. It could also be other things like failure to make repairs on a discriminatory basis, different rents, different credit requirements, things like that. The Fair Housing Act also contains a provision that makes it illegal to have discriminatory notices, statements, or advertisements. And this was mostly meant to prohibit, the old practice that was commonplace of landlords placing signs in front of their apartment building saying, whites only, or advertising it in that manner. It also applies to verbal statements too. So if a landlord were to say to somebody, I don't want to rent to you because of this characteristic, that would also violate the statute. But one of the most interesting things that has happened with this part of the statute is that for years and years, there weren't a lot of cases with this, under this provision, because no newspaper in their right mind would run a discriminatory housing ad. And in fact, newspapers got sued if they did, because they also could be considered making a discriminatory statement by publishing that material. So the newspapers wouldn't allow it. And then what happened was the internet came along. And places like, Craigslist and now Facebook, you can advertise online directly, and no one screens your advertisements to make sure that they comply with the Fair Housing Act. And so there's been a lot of cases in the last 10 years against either individuals placing ads on online platforms or against the platforms themselves. And you all may have heard Facebook just got sued by HUD. They just settled out a big case that was brought by a private fair housing group, the National Fair Housing Alliance, but they're still being sued by HUD because they basically make it possible when you take an ad out on Facebook, Facebook has this, highly evolved algorithm. You can decide who to show your ad to. And you can make those decisions based on protected characteristics, based on, sex, race, national origin, whether or not the person has kids, the whole deal. And so because Facebook has been facilitating discrimination in advertising, HUD has recently filed a lawsuit against them. Okay, other provisions, just quickly, the statute makes it illegal to misrepresent the availability of housing, right? So telling people housing isn't available when it really is. Why do we need a separate provision when that type of behavior would fall under the first provision, making housing unavailable? 3604D covers making false statements about housing availability even when they don't deny someone housing. When would that be? That would be when the person is a tester. And fair housing testing is a really important part of the enforcement of this law. Because it is so hard to know if someone's giving consistent information to all applicants or all, people who are inquiring, testing needs to be done to kind of ferret out, are people lying? Are people, telling only the black applicants one thing? And are they steering people to different units, things like that? And testing can be done not just for kind of renting apartments. It can be done for a real estate agent who's showing properties. It can be done at banks for people who come in and apply for mortgages. It's harder to do the latter because you have to have a credit profile and things like that. And the point of testing is to make the testers as equivalent as possible, but for the protected characteristic. But it is done. And every time it is done, it shows just pervasive discriminatory treatment across the board, across the country. So discrimination in real estate services and mortgage lending is against the law. It is also against the law to harass, intimidate, or coerce somebody who is trying to enjoy their rights to fair housing. This last section is kind of important because this can apply to people who are not housing providers or landlords. All the rest of the stuff in 3604 and 3605 really by its terms can only apply to like a landlord, a housing provider, manager, maintenance person, somebody who's in the business of housing, which makes sense. 3617 can apply to a neighbor. And a lot of the early cases, that is exactly how it was applied. A neighbor wouldn't like it that a black family moved in and they'd start harassing them and trying to make threats and get them to move out. So this can apply to people who are not housing providers. It can apply to just, anybody who harasses somebody who's trying to enjoy their rights to fair housing. Okay, as Eric talked about, and I won't talk too much more about it, there are some disability-specific provisions in the Fair Housing Act that require housing providers to make reasonable accommodations to practices and policies when requested and when it wouldn't kind of create an undue burden. And there's also design and construction requirements for certain covered sort of properties that are built after 1992 have to have certain accessibility features. And really, hopefully that is becoming, an accepted norm. There's nothing worse than when something is built and it's non-compliant because it's very, very expensive to fix that, and it's much better if it's built properly in the first place. Okay, quickly then, I want to talk about very quickly I'll talk about the theories for discrimination cases because this will be relevant to some new-ish developments. Discrimination cases can be brought under two different theories. Disparate treatment is when people who are similarly situated but for this protected characteristic are treated differently. So that's kind of the classic example. That's the sort of thing you could find from testing or something like that. And that's the most straightforward one. There's also cases that are called disparate impact cases. And this is when there's a policy that is neutral, that does not look like different people are being treated differently, but when it applies, it has a disparate impact on a group. And that impact is unjustifiable. And that's an important thing because, there's a lot of times when a landlord might have a policy or, a city might decide to do something, zoning or land use related that might affect different groups differently, but they have a good reason for doing it. There's any number of reasons why, housing providers and municipal governments make choices about their development or, how they're going to run their properties. And those are informed choices that need to be made. When disparate impact becomes important is when choices like that have an impact on a particular group and there is no good reason for it. And then it starts to look like maybe there was intentional discrimination, or maybe it wasn't intentional, but it's happening anyway, that a group is being affected and there's just no good reason for the policy to affect them in this way. In fair housing cases, this is a theory that works in all sorts of civil rights contexts, but in fair housing cases, that disparate impact can also mean practices that enforce and retrench segregated living patterns. And I'll give you an example of that when I talk about some of the new developments that have been happening in the law. So we've had, this is not exactly new, it's 4 years old, but in the world of fair housing, anytime a case gets to the Supreme Court, that's really exciting, because they don't often. So a case came down in 2015, this Inclusive Communities case, and the case involved allocation of low-income housing tax credits, which is a very complicated thing that I'm still not 100% sure I understand. But in essence, what was the argument that the plaintiff, tenants group, made was that the city of Dallas and the state of Texas were allocating these credits in such a way that all the low-income housing that was being built in the Dallas area was being built in just about 3 census tracts that were already, 85 to 90% minority occupied. And so by continuing to build low-income housing there, it was low-income housing which was probably going to have a disproportionate amount of minority tenants. They were just really emphasizing and retrenching segregated patterns. And that maybe if they would locate some of the new projects in more diverse census tracts, they'd be able to kind of create integrated patterns, and that would be beneficial for all sorts of reasons. So their argument wasn't that the city of Dallas or the state of Texas was intentionally discriminating. Their argument was sort of by using the tax credits, and they were following kind of a formula that the IRS created, which was another issue. But their argument was by sort of just taking these credits and just using them in the manner that they were entrenching segregated patterns, and they were having a disparate impact, therefore, on the community and on the people who would live in these housing developments and the neighborhoods. The case was an impact theory case, and the question was that had never been decided by the Supreme Court before was, can a plaintiff proceed with this kind of theory? The Supreme Court had upheld the use of that theory in other contexts, but had just never decided it in the housing context. Everyone was actually kind of a little worried because for a long time, the lower courts had just assumed that disparate impact theory was acceptable in a fair housing case, and it didn't seem like there was much disagreement about it. Normally, the Supreme Court hears a case when there's disagreement about an issue, or when the court wants to overturn settled law. So everyone was really worried in the fair housing community when the court took this case, because everyone thought, oh no, they're gonna say disparate impact theory is not available, and they didn't. It surprised a bunch of us by actually saying that it is. They said it's difficult. The plaintiff in this case didn't win. It was just the court saying you may proceed on your theory. If the city of Dallas or the state of Texas can provide good reasons for using the tax credits the way they are, then the plaintiff would lose. So it was a win, kind of in a theoretical sense. But it still looks like, these cases can be difficult because, there are a lot of reasons why people, particularly sort of large housing actors like municipal governments and large landlords, may create policies that have disparate impacts. So the big news was just that the plaintiff was allowed to use that theory, and that theory remains available for fair housing lawyers. The second big case that came out 2 years ago was Bank of America versus Miami, and it was actually Miami versus Bank of America. The parties flipped around when they got to the Supreme Court. But Miami was suing not just Bank of America, but also Wells Fargo. And Miami is not the only city to want to sue big banks. Many other cities around the country have also done this. What are they suing the banks for? Giving out predatory loans in majority minority neighborhoods. So what is interesting here is that the cities were not suing on behalf of their residents. So sometimes, governments can file a lawsuit on behalf of their citizens because their citizens have been injured. That wasn't going on here. Those lawsuits got filed, by the citizen groups themselves or by fair housing groups. Here, the cities were filing lawsuits against Wells Fargo and Bank of America saying, we, the cities, have been hurt. Miami actually suffered a harm because their tax base took a big hit when all these neighborhoods went into foreclosures. Their property values plummeted, because once you get a string of foreclosures in a neighborhood, there's a domino effect in it, and it gets worse. They were also claiming that, their municipal services got stretched to serve and deal with the problems of huge neighborhoods with mass foreclosures. Safety, fire and safety and police and things like that. So what the cities were arguing was that they themselves were hurt by predatory lenders targeting minority neighborhoods, which resulted in foreclosures. And so then the question that came to the court wasn't, does the city of Miami get to win its fair housing lawsuit against Bank of America or Wells Fargo? It was more, can the city even bring a case like this against the bank? Can the city claim that it got hurt when it wasn't the target of the bad behavior? The predatory lending, the targets were the homeowners who, took out bad loans, lost their homes, and went into foreclosure. So it was really, can the city kind of maintain it's called standing. Does the city have standing to sue? And again, the court said yes. The court said yes, you may have a hard time, Miami, you may have a hard time proving, that these banks were really the cause of all these problems, but you could at least bring a case. So both of those cases were important just because they kept legal theories available for fair housing advocates or for governments to use. Like I said, they didn't actually mean that the plaintiffs in those cases won. They just meant that they could keep pursuing a case in court. Okay, so I'm going to talk about a couple of recent cases or a recent issue in Missouri and in other federal courts as well. And that is the issue of sexual orientation. So as we talked about, sexual orientation is not a protected characteristic in either the federal statute or in Missouri's state law. For a long time, any court that would be faced with a case where a same-sex couple or a gay individual were claiming that they'd been discriminated against, the courts would just summarily toss that case out because they'd say, no, sexual orientation is not covered. Your claim is invalid on its face. In recent years, plaintiffs have been bringing sexual orientation claims, both in employment and in housing, basically arguing that sexual orientation should actually be considered a component of gender or sex, which is to say if someone's being discriminated against because they are gay, they're really being discriminated against because they're failing to conform to sort of gender or sex-based stereotypes. If our gender norms are, only opposite sex people are in relationships, then someone who fails to conform to that could arguably say they're being discriminated against because of their own sex, or because of the sex of the person they choose to, make their life with, or because they're just not conforming to stereotypical behavior. And the reason why this is something that plaintiffs started arguing was because there's been Supreme Court cases about sex and sex stereotyping. The most famous one was brought by a woman who didn't make partner at her accounting firm, in part because she wasn't feminine enough. There was no sexual orientation claim there. It was just She was a woman who didn't like to wear makeup and had short hair and, cursed like a sailor. And they said her partners, when they voted on her to make partner, pretty much told her, you need to be more feminine and stop cursing and try wearing a little makeup sometime. So she was able to bring a claim for sex discrimination, but the court wrote a little piece saying the form of discrimination here is that she's failing to be feminine enough. She's failing to conform to the stereotypes that we would expect, the world expects of a woman. So plaintiffs nowadays, and in the last 10 years or so, have started to use that as their argument for why sexual orientation discrimination may be considered sex discrimination. And some of them have succeeded. So in some federal courts, in a district court in Colorado recently held this in a fair housing case, and the Seventh Circuit Court of Appeals, which is a large federal appellate area that includes Chicago and Illinois, have held that that theory holds, that sexual orientation can be considered a form of sex discrimination, and therefore sexual orientation discrimination claims can be brought under the Fair Housing Act or under Title VII, which is the Employment Discrimination Act. It's important to remember that these claims only need to be brought, or this argument only needs to be made in states that don't have sexual orientation provisions written into their state statutes. And 28 states, I think, now don't have that, and Missouri is one of them. Because if it's in there, then you can just use that. So one of the interesting things that I see is, first of all, the federal district courts are not in complete agreement. Some courts have found that it is not, sexual orientation is not the same thing as sex discrimination, or can't be kind of described that way. And one of those federal courts is from a very recent case here in Missouri, just outside of St. Louis. I want to get the parties' names correct here. And this is this case, Walsh versus Friendship Village. So in this case, Mary Walsh and Beverly Nance are a same-sex couple. They've been together for almost 40 years. They're in their early 70s. And they got married legally in 2009 in another state. But their marriage is, of course, legally recognized now in Missouri. And as they're getting older, they thought they'd like to move into a retirement community that had sort of different levels of assisted living, the whole deal. They visited the facility, they liked it, they interacted with the staff and the residents, they picked out their floor plan, they went through the whole thing, they put down a $2,000 deposit, and they were on the wait list, they were all set to go, and then they got a phone call from the residential director asking what their relationship was. And so when they said, oh, well, we're married, they got a call back saying that the Friendship Village cohabitation policy would not allow them to live together in a single unit. Despite the fact that they were legally married, they were considered cohabiting. And so they got a letter that said, your request to live together in a unit does not fall within the categories permitted by longstanding policy of Friendship Village, Sunset Hills. The cohabitation policy was attached, and it said, it is the policy of Friendship Village, Sunset Hills, consistent with its longstanding practice of operating its facilities in accordance with biblical principles and sincerely held religious standards, that it will permit the cohabitation of residents within a single family unit only if those residents are related as spouses by marriage or as parent and child or as siblings. The term marriage is meant to mean the union of one man and one woman as understood in the Bible. So that was a pretty clear statement. They brought their case in federal district court, are arguing basically that they're being discriminated against based on sexual orientation, but that should be read as sex discrimination, and they lost. The federal district court said your case has to be dismissed because that is not sex discrimination. Like I said, other federal courts have come out differently, and whenever we have courts that come out differently on something, at some point, that's got to go to the Supreme Court. It's not really a tenable situation to have kind of certain areas of the country interpreting a federal statute one way and certain areas interpreting it another way. The other interesting thing that happened, though, was right around that same time, like literally within, oh, this one doesn't have a date on it. I mean, literally within like a few weeks of this opinion coming down in the Walsh case, Lampley versus Missouri, an en banc opinion by the Missouri Supreme Court, came down interpreting Missouri's human rights statute differently, to say that sexual orientation claims can be brought under kind of the identical language of the state law, that sexual orientation claims can be considered sex discrimination under state law. So we have a very interesting, disparity now between state and federal law. And like I said, we've got disparity between how the federal courts are approaching it. So I think this is an issue that is not going to go away anytime soon, and it'll be very interesting to follow. Okay, how am I doing on time? Okay, I'm going to finish up in just two more very quick slides. Couple of other developments that are happening. So in 2015, HUD passed the Affirmatively Furthering Fair Housing Rule. And I think you guys have heard some about this. I don't know if Randy talked about it much in this is kind of his life now. But what this rule requires is that for any recipient of federal housing funds from HUD, which is basically every community in the country, that they are supposed to undertake an analysis of how they're using the money and how they can use it to further the goals of fair housing, which also means, looking at integration and segregation patterns and trying to break up segregated patterns, make sure that there's true housing choice within the community. That's always been part of the law. The Fair Housing Act requires, and HUD's implementing regulations require that it act in a manner to affirmatively further fair housing. It wasn't taken very seriously for a long time. And so a lot of municipalities were able to take HUD money and just sort of sign a little statement saying, sure, we're doing good things with this. And too many times they weren't. In 2015, this regulation was passed that basically just put a little more teeth in it. Said municipalities that want to take HUD money need to go through this process and figure out what's the best way to use this to help everyone in the community and really reach fair housing goals instead of just paying lip service to it. And as part of that, they were provided with these analytical tools that I don't know how to use, but these sort of data analysis and mapping tools that are incredibly sophisticated to figure out, best ways to use money to serve the most members of the community and help further fair housing. So everyone was pretty excited in the fair housing community when that happened, because I think most of us recognize that a lot of the most important decisions really are made by governments that affect lots of people. Things like zoning and development affect affect everybody that lives in the community, and this was a good tool. And then the regulation was put on hold with the incoming Trump administration, with the Ben Carson HUD as HUD secretary. It's been put on hold until 2020. To the great credit of many communities, including this one, they're going ahead with the old version. They're going ahead with the 2015 rule. They're holding themselves to that standard and using those tools and still doing that analysis and making sure that they're using money in a equitable and good way. So just because they don't have to, because since the rule's been put on hold, some communities are still doing that, and this is one of them, and I greatly, greatly appreciate that. Okay, one more quick one that's particularly exciting to me, because this is something I've worked on, is the DOJ has also recently come out with an initiative to raise awareness of sexual harassment in housing. This is a topic that it hasn't really been on the radar screen of the public, certainly, but even lawmakers and courts and people who ought to know don't. This is probably because it almost exclusively happens to poor women. It often happens to women who are young and poor and housing insecure. It doesn't get reported, but we know it happens. I've done research that shows it happens quite a bit. I randomly interviewed 100 women, and 100 low-income women, and 10% reported having been pretty seriously harassed by landlords at one point in their life. I imagine that number is probably greater if I were able to do a bigger study. So DOJ also knows that this happens, because sometimes we would get complaints and do cases. So they've put money into it to trying to raise awareness among providers of housing, but also people who serve the communities that are most affected. And that often involves just getting together in a room and talking. And so we're going to do that, and I'm very excited. And on May 2nd, here at the law school, we're going to hold one of these informational sessions, and it's pretty exciting because it's going to bring in lawyers and people, hopefully just so we can get a sense of what the problem is and what, where to report it and how it gets handled. So that's a really encouraging sign coming out of DOJ. That is the end of my presentation. I've left 10 minutes for questions, if anyone has any. I'd love to hear them. One has to have a question. Yes. Oh, yeah, it is open to the public. Yes, I'm sorry, I should have said that. It is open to the public. It is May 2nd at 10 o'clock at the law school. It's in our courtroom building. There's going to be a certain number of participants it's going to be a round table. So there's going to be some kind of attorney participants, but then we've also got a place where people can just sit and listen and watch and ask questions too. But yeah, there'll be kind of the round table. We'll have I think 8 attorneys maybe. I don't know. We're still figuring out exactly what it's going to look like. It's in the courtroom of the law school building on campus. Yes.
Do you provide outreach to local groups, particularly young, poor women?
I am personally, like myself, I am happy to do it. Yes, I mean, I think just as a not as a representative of any group, but just yes, I would certainly do that. I'm happy to talk to anybody, and I hope if we can get people to come to this session, that they'll also be people who have more direct, who work. I think we've got the Community Action, hopefully True North, Columbia Housing Authority, sort of the people who have the best pipeline to the community that's affected. But yeah, I personally would be happy to do that too. We used to do, when I first started at DOJ, we used to do outreach, and it was really helpful and really effective, and then that money went away. And so the money just came back DOJ and the U.S. Attorney's offices are doing this, but I've been a lonely voice trying to do it just on my own also, so.
The comments on the extent of the federal law and the comments on the extent of the state law and on Columbia's further extensions that you cited, how extensive are those long-reaching extensions that Columbia has enacted in other cities, other states, and is it growing or contracting, or what is the trend?
The trend is upward in the sense that many states have added additional protections or additional classifications to their statutes. And sexual orientation is probably, and gender identity and expression are probably the most common. Also age. Age is not a protected characteristic in the Fair Housing Act. There's some provisions that allow for sort of senior or adult housing, but just in general, being discriminated against because of your age is okay unless a state has specifically prohibited it. So age, sexual orientation, sometimes veteran status, marital status, and source of income are 5 of the ones that are very often put into state and municipal laws. Municipalities tend to lead the way on this. They tend to be kind of first. And once enough cities in a state start adopting laws like that, oftentimes the state comes next.
How far ahead is Columbia?
I'd say Columbia is Well, certainly it's certainly out ahead of the state of the state of Missouri. It is about on par, I would say, with St. Louis. It is similar to larger cities in protecting. I don't know off the top of my head about Springfield. Do you know? Yeah. I don't. Oh, the question was about like St. Joe and Joplin and Springfield. I don't know. I want to guess no, but I don't. I don't. Rose might know.
I had heard from another human rights commission member in another city, and I'm thinking it was Springfield, where they, or maybe St. Joe, I can't remember which one, they actually repealed some of their ordinances.
Oh.
And they were trying to get a better score on the Municipal Equality Index from the Human Rights Campaign, and were having difficulty knowing how to approach it. But I'm thinking it was Springfield. Yeah, it was Springfield.
Okay. Oh, yeah. I'm surprised to hear. I mean, usually it goes. Usually there's sort of one direction that travels, which is usually, protections get added. They don't often get taken away. That's a new one for me to hear. But yeah, I mean, I would say Columbia is pretty far out in front, considering other towns of this size or cities of this size in Missouri, certainly.
I was just wondering what, since the protections that are provided by like municipalities, but not federally at a federal or state level, what do the people that may have experienced that discrimination really, what are their options? Really, if it's just at a city level, what are their options?
Yeah, so the available remedies and the available process is much, much less, right? I mean, if you have a case in federal court under the federal statute, you can get millions of dollars, and the person can be, be given fines and all sorts of things. Under Columbia's municipal authority, I think it's a $500 fine. Is it?
I think it's maybe 1,000 now.
Is it 1,000? Okay. Yeah. So it's just there's a lesser.
But then they can also face retaliation from if I understood right. But then they could also potentially face retaliation from their landlord for having.
Oh, yeah, then the question is, so what if someone does that and they might get retaliated against? And so the retaliation would, again, be another violation.
But would that be at the federal level, but not state, if I understood correctly?
It would be, yeah.
Okay.
It would probably not be federal, because it would not be retaliation for violation of the federal law, which is, right.
Can I add to this?
Yeah, please do.
So basically, in Missouri, there was a Supreme Court case back in the early 1990s called Yellow Freight. It came from the city of Springfield. And before that time, municipalities could seek other remedies, and kind of like the state and the federal government do when there's discrimination complaints. But basically, the Missouri Supreme Court found that we could no longer do that, and that basically the only way a municipality can enforce its ordinances is through prosecution in municipal court. So oftentimes when people want to file a complaint and then they find out that, we can't force them to, the employer to give them their job back, we can't force the housing change or some compensation, they want to go either file at the state or federal level, but on some protected categories they can't. So their only remedy is here. And unfortunately, because of that Supreme Court case, we're really limited. Sorry.
Yes, I was wondering about race. We certainly have the vestiges of disparate impact here in Columbia and the results of redlining. Molly Metzger came from Wash U a few years ago and showed a mapping program that you could use to see those vestiges. What, if anything, is being done about that continuing impact on neighborhoods?
And so that's such an important point, because housing discrimination, and particularly redlining and state-sponsored discrimination, kind of baked in segregation and inequality that is not easy to just snap your fingers and make go away. And so that's why the affirmatively furthering fair housing language is in the statute and is in HUD's mandate, because the recognition is the positive, proactive steps have to be done. If you just do nothing, the status quo will maintain, because housing is it's a lagging indicator. It's, decisions made 40 years ago affect what neighborhoods look like today. So I know that, I know that Randy Cole and some of the folks here in the city are actively working on looking at those issues and trying to take steps to address them. I don't know exactly what they're doing, but it really does require a overarching focus, because this one person or one housing provider can't really undo all the damage that has been done. There's programs now for community reinvestment. Banks, are supposed to, have lending in more equitable ways. But then we saw from, the 2008 housing crisis that a lot of banks really weren't. I'm not speaking about any of the banks here in Columbia, but in general, many of the major banks looked pretty bad after that, because they were giving not only redlining and giving the good loans in the white neighborhoods, but then targeting the minority neighborhoods for the predatory loans. And so there's so much more to be done. The availability of data and mapping is huge to be able to see those things. I mean, you can map every residential mortgage loan that's been given in particular areas and run numbers on that. So that's an important tool. So I guess I don't know. I think there's a lot that is being done in general. I don't know specifically what our city is doing, but I know they are very involved in that. And yeah, Eric, did you have a
Yeah, I wanted
comment?
to do a point of clarification about the Yellow Freight decision. So after that decision came down that took away enforcement powers from the local commissions, the Missouri Commission on Human Rights and some local commissions got together to try and figure out what could be done to, ameliorate that. And so the plan that everybody came up with was to amend the Missouri Human Rights Act to add a couple sections that would let the Missouri Commission certify local commissions as being substantially equivalent to the state law, and through that get enforcement power back, but only on the protected categories under the state law type of thing. Currently, only 2 local commissions are substantially equivalent, the Kansas City Human Relations Department and the St. Louis Civil Rights Enforcement Agency.
Okay, well, thank you all very much. I appreciate it. Thank you.
All right. Thank you so much, Professor Oliveri. So just wanted to add something. We talked about protected classes and adding those in the city of Columbia. In the last year, we have added, I think, 5 to 7 new protected classes into the city of Columbia, as she mentioned in the presentation. And currently with the Commission on Human Rights, we've been talking about adding veterans status as a protected class. So if that is important to you and that's a conversation you want to have, I invite you to come to our meetings the first Tuesday of every month at 5:30 here in City Hall. Anyway, that's my plug. So it's time for lunch. Hooray. The Columbia Board of Realtors has sponsored lunch for us. Lunch is in rooms 1A and 1B, which is out here to the left. We'll resume promptly at 1 p.m. with Nate Johnson's presentation called Focus on Fair Housing, which is in this room. And then we have a Building Inclusive Communities workshop. If you're attending that workshop, you should go to room 1C, which is down the hall, just past the elevators, across from the display cabinet. If you are attending the Focus on Fair Housing presentation, please be back in this room exactly at 1 p.m. Don't be late. Realtors, please be sure to sign in before the session begins. Enjoy your lunch. Thank you.